Hello and welcome to the webinar. Today's webinar is Title VI with RLS, and I'm just going to walk through a couple different technology tools in case you haven't done a webinar with us before, so that everyone is prepared for the webinar and knows what to expect and how to ask questions. So the agenda for today is I'm just going to do a brief technology review, and then I'm going to turn it over to Matt at RLS Associates to do the presentation. We're doing a Q&A throughout the webinar today, so there will not be a designated Q&A section. If you have a question, please enter it in the questions bar at any time, and we will answer it as you ask those questions. A couple things to know about how to use this webinar technology. You can ask questions using this section that says questions here, and as soon as you type a question, we receive it. I will then read those questions to Matt, and he'll answer them as they come in. Just a reminder, this is the federal overview of Title VI. Any questions related to specific OTAT aspects of Title VI or Black Cat will be addressed later this year on a different webinar with OTAT staff. Few things to note about your screen. You can change your screen between full screen and half screen using this button here. It should be on your screen underneath the microphone button. You can also minimize your control panel using this orange button with an arrow, so that'll hide this so you can see the screen better. And then finally, if you have any concerns or questions, if you can't hear us at any point during the webinar, you can feel free to call or text me at this number. It's 612-998-0155, and I will be happy to help you. You can also send in any issues that you're having through the questions box, and I will receive that and we will respond. So with that, I'm going to turn it over to Matt to begin the presentation.
Great, thank you, Mariah. Good afternoon, everyone. Just checking that everyone can hear me. If Mariah, you can just confirm that the audio is okay?
Yep, audio is working great.
Perfect. All right, good afternoon, everyone. I'm Matthew Bussey. I'm an associate at RLS Associates. Just a little bit of background. RLS Associates has been doing transportation compliance consulting for about 32 years now, and we work doing both providing technical assistance to a number of states and their DOTs. We also perform triennial reviews on behalf of FTA and state management reviews on behalf of FTA. And we also work with a lot of states to perform subrecipient oversight. So our firm has been around for quite some time, and we've got about 35 people, many of whom have significant backgrounds running agencies and those types of things. So we have a lot of experience in our firm. Me personally, I'm a lawyer by trade. I practiced law for about 10 years, and then I became what I consider a reformed lawyer, in that I stopped practicing traditional law and started doing triennial reviews on behalf of FTA. So I do triennial reviews, and I've been doing that for years. And I've also done a lot of subrecipient oversight reviews, similar to what I was explaining before. So this today's discussion will be about FTA Title VI requirements. And before we get into that, we've got the legalese for you. Everything that we're providing here today is for educational and informational purposes only. Please don't sue us. What we're going to cover is basically the history of Title VI, the requirements under Title VI, what components should be in a Title VI program, what components are required, the requirements for small fixed route service, and then common compliance findings. And I can definitely share my insight on a number of those, given that, first of all, since I perform triennial reviews, then I know what things trigger a finding for agencies. And in addition, then because we do state management reviews, then we know what types of oversight have to be conducted by the states of their 5310, 5311, 5307 subrecipients to ensure that the state doesn't get dinged when they have their state management review. So we'll go through each of these areas, and I hope you find it valuable. So we'll start with the historical overview. The Title VI is rooted basically in a number of the issues that were being experienced in the 50s and 60s, where things were still highly segregated, especially public transit. As you probably know, persons of color were traditionally mandated to only ride in the back of the bus. Signs obviously directed passengers to sitting in the back of the bus. They had separate lavatories, separate bathrooms, water fountains were separate. And so there was a lot of discrimination that was occurring, and obviously began to have protests for public transit. We all remember Rosa Parks sitting in the front of the bus. And that ultimately led to Title VI being enacted as part of the Civil Rights Act of 1964. And this is it was a wide sweeping legislation signed into law in June 1968. And it's basically made up of 12 different titles that all cover various activities and places, but are all oriented towards preventing and prohibiting discrimination. And so the Title VI that we'll be talking about today we're going to be looking at it from a transit focus, but it's going to be prohibiting discrimination in connection with programs and activities for any agency that receives really any type of federal financial assistance. Its purpose was to outlaw discrimination on the basis of race, color, and national origin. And you'll probably be aware that that has been expanded through some of the other titles. For example, Title VII is the Equal Employment Opportunity Act, and that was added in the same legislation prohibiting discrimination against sex or religion in the workplace. And over the years, a lot of different areas such as low-income, impoverished groups have been added to these as well. But for today's discussion, Title VI was originally passed to only cover race, color, and national origin. It was intended to be a broad institution-wide application, meaning every agency in the United States that receives any type of federal dollars has to abide by it and not discriminate. And today, like I said, we're going to be focusing strictly on transit, and but that does not relieve the obligation of entities to comply with other Title VI requirements as well. The basic principle of Title VI is that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So again, any agency that receives any federal dollars is subject to Title VI. The main principles under Title VI are that the level and quality of public transportation service is provided in a non-discriminatory manner. It promotes the full and fair participation in public transportation decision-making without regard to race, color, or national origin. And we'll see that as a recurring theme. One of the main issues with Title VI is having a robust public participation process, allowing minorities and people of low income a voice in transit decision-making processes. So we'll get into this a little bit more later, but for equity analyses, if you're going to be raising fares or making major service changes, then it's crucial to go through that public participation process. I know that many of the agencies that are partaking in this call today probably aren't above the threshold requiring equity analyses, but we will touch on them a little bit, and we'll discuss what the requirements are for agencies that are below that threshold. And additionally, Title VI is meant to ensure meaningful access to transit-related programs and activities by persons with limited English proficiency. In other words, those people who speak English less than very well. And we'll touch on that in a little bit as well. So moving on to the requirements under Title VI. The first and foremost is that all federal agencies that receive those federal dollars must promulgate rules implementing the act. And the key documents here, the key governing directives for Title VI are 49 CFR Part 21. That's the actual the law that codifies Title VI. And then there is a circular that FTA put out specifically as Title VI applies to transit, and we'll send that around after this this presentation is over. It's very helpful. It's about 130 pages, but not all the chapters apply to everyone. We'll kind of go through and delineate what chapters apply to whom, but it's very helpful, has a lot of good examples. So the basic requirement under Title VI is that all direct and primary recipients have to document their compliance, that they're adhering to Title VI. And part of that is that they have to develop a Title VI plan. And that Title VI plan is submitted to FTA every 3 years. And one of the reasons that you kind of ask yourself, why do I have to keep sending it in every 3 years? And the main reason for that is because of demographic changes. First of all, the Title VI plan is based on census data and demographic data showing how many people are in your area and who you're serving. And in addition, then there could be changes to the demographic makeup of your area. And so by having that submitted every 3 years, then FTA is assured that you are taking into account the most recent demographic data and exercising your responsibilities accordingly. And for those agencies that are subrecipients, your responsibility is to submit your Title VI program to the direct primary recipient, which in this case is Minnesota DOT. So subrecipients are said to stand in the shoes of the recipient. So basically all federal obligations under Title VI flow down along with the money. And so when a subrecipient receives funds from a direct recipient, then they also are responsible for adhering to Title VI protections, just as the original recipient, Minnesota DOT, is responsible for. And so again, subrecipients must submit their Title VI programs to the primary recipient. And the subrecipients, by doing this, are assisting the primary recipient in its compliance efforts. So all the things that should be happening under Title VI, Minnesota DOT, they may not have enough connection with all their different recipients to know that they're engaged in proper Title VI adherence, but they know that the subrecipients are doing that because they've got their own Title VI program that they're responsible for adhering to. And the primary recipient, Minnesota DOT, will also engage in some oversight activities to spot check recipients periodically so that they can show FTA that they are also making sure that the subrecipients are doing everything that they're supposed to be doing. And unlike with FTA, where they require the recipient's Title VI plan to be submitted every 3 years and actually 60 days prior to the expiration of the old Title VI plan, so they have a little bit of a chance to review it. Whoever your direct recipient is, your primary recipient, they determine how often the subrecipients submit their Title VI plans. And it's probably similar. It's probably on a 3-year basis, rolling basis, but it's up to them. Now, contractors are a little bit different. And so if you're a subrecipient and you have contractors aren't required to have their own plan like subrecipients are. What contractors do is they are just responsible for complying with whatever the subrecipient's Title VI program says. So if you're using someone to conduct demand response service, then that contractor, they have to adhere to your plan. So again, the dollars flowing down, everybody's responsible for whoever was paying them what their responsibilities were. They all flow downwards. And in that case, the subrecipients have responsibilities to ensure oversight and ensure that the contractors are actually doing everything that's in the subrecipient Title VI program. So for agencies that receive funding directly from FTA, not Minnesota, then they would be responsible for submitting their plans to FTA. And in the instance where an agency receives funding from both, say you get 5307 funds from FTA and you get 5310 funds from Minnesota DOT, then you'd be sending your program to both. There are other special circumstances that might impact you, and basically the bottom line is that with all of them, you're still required to develop your Title VI program and submit periodically to your primary recipient. So moving on, we can look at the components of a Title VI program. A program, as we were just saying, is required for direct recipients, subrecipients, lower tier subrecipients. Again, anybody who's receiving money from FTA. No program is required for contractors, but they are again responsible for implementing the recipient's plan. One of the main things that's required is the Title VI assurance, which is every time anyone applies for financial assistance from FTA or frankly any other federal agency, then they are required to assure that agency that they will comply with all the responsibilities and protections that are part of Title VI. This is commonly called the standard assurance. And so they do that when they originally apply for assistance. And then in addition to that, then on an annual basis, then they assure that with their annual certificates and assurances, certs and assurances. And the primary recipient is responsible to collect and submit Title VI assurances from all of its subrecipients. For first-time applicants, then not only do they submit that standard assurance, but they also need to provide their compliance history. Basically, if in the last 3 years they've received funding from any other federal agency, perhaps like Federal Highways or whatnot, if there have been any reviews about Title VI, then the agency needs to provide that with their application, basically saying, okay, we had a Title VI review under FHWA, and these were the findings, these are the status and disposition of those findings, and any recommendations that were made by the reviewers. Basically have to provide all of that to FTA so they have the background of how you've performed with regards to Title VI for other federal agencies. And in addition, you also have to describe any pending applications if you're applying for federal funds from other federal agencies, and you have to aver and state that you have had any findings of non-compliance with regards to really any civil rights, but specifically and most importantly, obviously, Title VI. The most important document, and this is again one that we will send out after the presentation is over, is FTA Circular 47021B, and that's the 130-page one that I described earlier, and it really is just a roadmap for really everything that you're responsible for, and it has a lot of best practices and examples as well. And for those of you who will be on the call, I believe 2 weeks from now, talking about Title II ADA, then you'll find out then, if you don't already know, that not all circulars are actually considered to have the force of law, but FTA Circular for Title VI 47021B does have the force of law. So it is basically everything in there. You can rely on it and know that these are what you are required to comply with. We've got a link here as well if you want to download that. Hasn't changed since 2012. So the applicability of the circular is basically all subrecipients and recipients are required to comply with chapters 1 through 3. And really the first chapter is just the introduction and background. It's talking about the authorizing legislation and everything. So it's not that important, but it does have definitions which will serve you for the rest of the circular. The second chapter is the program overview, talking about what the goals are and what reporting contracts or reporting requirements are and that type of thing. And then chapter 3 is the big one. We're talking about all the major requirements and guidelines that apply to, throughout Title VI, regardless of how big an agency that you are. Chapter 4, which we'll talk about on the next slide, is for fixed route operators with 50 buses and that have a population of over 200,000 people. Chapter 5 is specific to state DOTs, and Chapter 6 is for MPOs, Metropolitan Planning Organizations. So I did want to just clarify, I don't know how many people on this call would fall above this threshold, but the requirements for fixed route transit providers, it applies once again if you're in a UZA of 200,000 or more in population and you have 50 or more buses. And I just want to clarify that's in peak service, and also that includes both federal and non-federally funded buses. That's a mistake sometimes we see where people think they're below the threshold and therefore they don't have to do things like conduct equity analyses, and they think that they're just counting their federally funded vehicles, but it's actually their federally and not non-federally funded buses. So that's an important distinction to make. Okay, other chapters of the circular cover compliance with DOT regulations, the civil rights compliance reviews. There are reviews that FTA does in addition to their triennial reviews that are specific to the various civil rights areas, and actually also some to procurement and finance. So there are Title VI specific civil rights reviews, and then also the circular covers complaints, which is a big area that we'll be touching on later. Complaints is a very big area, partly because it is the easiest way for the public to alert you to a potential problem in how you are conducting your Title VI policies. So for most subrecipients, the first 3 chapters are the only ones that are going to be applicable. That's true for demand response as well, since you are not fixed route. So we're just looking at that authorizing legislation and background, the program overview, and then the requirements that are applicable to all agencies that receive federal dollars. So the elements of a Title VI program are the Title VI notice to the public, and we'll get into each of these in a moment. The complaint procedures, the complaint form, a list of investigations, lawsuits, and complaints, your public participation plan, your language assistance plan, also known as an LAP, information regarding siting of fixed facilities, and then the table depicting the racial composition of non-elected boards and committees. One thing to note, because we're not really going to get into it in the course of this presentation, but the siting of fixed facilities, it's important to know that while equity analyses are only required for agencies that fall above that threshold that we were just discussing, you do have to do an equity analysis for siting of fixed facilities. So if you're going to do a new construction of a transit facility or anything like that, you do have to do an equity analysis, and that applies regardless of whether you're below or above the threshold. That's something that we occasionally see as well, where recipients are unaware of that. So starting with the notice to the public, this is one of the key requirements because most people don't know what Title VI is, and we'll kind of see this in a little bit too when we're discussing complaints. People will rarely make a complaint where they are actually citing to Title VI. Most people are completely unaware of what it is, and so it makes it very important, first of all, to have these notices telling the public about what the rights are under Title VI. And it also impacts the complaint process where your agency identifies Title VI complaints because again, oftentimes they're not going to cite to Title VI. They're going to say, I was discriminated against based on this color of my skin or something like that. And so they usually don't cite to it specifically, but it's so it's very important in the notice to the public. And the basic components of that notice, first of all, you're giving a statement of protections, saying the things that they're protected against, and we'll get into the specifics here in a moment. You'll state that the entity, because it receives federal dollars, complies with Title VI, and the program should include a list. The program, meaning your Title VI plan, should include a list of the locations where the notice is posted. And really, those should be any areas that are public facing. So, if you have a transit facility and people can go there and buy bus passes or something like that, then you should have the Title VI notice, at the check-in desk. You should have them on your buses. You should have them conspicuously posted basically anywhere the public might see them. And this is a real key factor that is going to be a recurring theme throughout this discussion. But what you have in your plan is basically gospel. So if you say in your plan that you're going to post Title VI notices on all of your buses, then when a reviewer goes out there to determine your compliance, if your plan says it, they're going to look for it. And there are certain things, like for buses, for example, in the actual CFR, then it says that the Title VI notice should be posted in buses. It doesn't say shall. And so there's a little bit of wiggle room right there. And the way we treat that when we're conducting training or reviews is, if it's not in your plan, if you didn't include that was a requirement in your plan and you don't have the notice posted in buses, then we're not going to give you a finding. However, if you do have it in your plan, we're going to hold you to that. And so it's very important that you delineate exactly where your Title VI notice is going to be posted, and then even more importantly, that you adhere to whatever you say you're going to do. So the content of the Title VI notice is a statement that the agency operates its program without regard to race, color, or national origin. And I think I touched on this earlier. Don't expand on those three. In the actual Title VI notice, we don't want to see disability. We don't want to see low income. We don't want to see anything except for race, color, or national origin. And believe it or not, that's actually a finding if you're strictly interpreting what the requirements are. And so usually if we were on site, then we'd just, kind of say, hey, you've got extra qualifications in there that aren't supposed to be in there. Go reprint it out. We'll obviously try and not be too rigid with them, but at the same time, the notice should only include those three things: race, color, and national origin. The public notice should also include the procedures that the public should follow if they want more information on the recipient's Title VI obligations and the protections that are afforded the public. And it should also include the procedures to file a Title VI discrimination complaint against the recipient. So those are the three things that are supposed to be in your public notice, Title VI public notice. So where does an agency find the notice content? Fortunately, you don't have to reinvent the wheel or anything like that. There's a model template in the circular, and I believe that Minnesota DOT also has a model template. And so you can base your notice on the language that's in Minnesota DOT's own notice. And just the one thing I'll caution here is, again, and this is also true because recipients oftentimes kind of they'll take someone else's plan and try and make it their own. When you do that, remember that whatever's in that plan, you have to you have to comply with. And so the problem with this is that you have some agency that's maybe got 10 buses, and they go online and they look around and they find MTA's Title VI plan. They're in New York City. I actually did their training review last year, and they're in New York City, and they're the largest transit agency in the Western Hemisphere. And so you can imagine that there's going to be a lot of complicated stuff in their Title VI plan that probably isn't relevant to the little system that has 10 buses. And so the problem, just the caution, I guess, is that try and find, if you're going to be mirroring or using someone else's Title VI plan as an example, or even their Title VI notice as an example, try and find an example that is a similar sized agency, and then tailor it to make sure that whatever is in there makes sense for your agency and is something that you can actually comply with. So model template provided by Minnesota DOT, and there's a model template in the circular. Just make sure that you tailor it and you make it yours. So what if your agency, your government, Minnesota DOT already has language for the Title VI notices? The governing board wants to use that language. That's perfectly fine, as we just discussed. Just make sure that's yours, and that's totally all right. The only thing, you can put as much language as you want in your Title VI notice. You just have to make sure that you include those 3 key provisions that we talked about just a moment ago. So the next requirement is disseminating the public notice. And again, agency office, any place public facing, buses should be posted on buses. But again, as we discussed, that's kind of up to you the way that the CFR is currently written. And then in this day and age, then everything has to be on your website. That's your handshake to the world. Go to the website, make sure that your Title VI notice is on there. Similarly with your plan, you'll want the Title VI plan to be on there, and you'll want to make sure that it's your current plan. As these get replaced every 3 years, sometimes we encounter situations where an agency will have their 2014 plan instead of their current plan, and so that's always a bit of an issue. Like I said, the main things that change from plan to plan as you do these are demographics, but at the same time, then you want to be publicizing to the public your notice and your plan that are the most current and accurate. And in your plan, you should definitely describe where you're going to put the notice. And also, we'll get into this in a little bit, but also get into, also describe the languages that it will be translated into. So your Title VI notice and your Title VI plan must be translated into languages other than English. And the way that this is accomplished is, first of all, a demographic analysis, and then what's called the 4-factor analysis. So we'll get into that in a second here. The documents that are supposed to be translated are called vital documents. And the easy way to look at vital documents, it's really just any document that communicates rights. So for example, a consent form, a complaint form, if those aren't translated, then someone can't understand the form and know what they're consenting to, or know how to file a complaint, that type of thing. So consent forms, complaint forms, intake or application documents, if someone needs to apply for ADA eligibility for complimentary paratransit, those applications should be translated. Notices of denials, losses, decreases in benefits or services. So if you're planning on decreasing service, or if you denied someone's complaint, then all of those should be translated accordingly. And then notices advising LEP persons, limited English proficiency persons, of what language assistance services you provide. A quick note on Google Translate. I think, first of all, that it's a fantastic resource, especially when you have a voluminous website and it can translate into 26 different languages or whatever. I think that's a great thing to have, but just know that for vital documents, then FTA really frowns on what they consider mechanical translation, of which Google Translate is an example. So if you want to have Google Translate for your website, then that's perfectly fine, but your vital documents should most likely be embedded PDFs that aren't affected by Google Translate. And what you want to do is you want to make sure that you have someone who speaks whatever the relevant language is, read it over and make sure that it accurately conveys the rights and the spirit of those rights to the writer, to the reader. So for complaint procedures, all covered entities must develop procedures for investigating and tracking Title VI complaints. And the procedures for those must be available to the public. You must have a complaint form and a complaint process that are available to the public. And obviously the key place where people are going to find that information is on your website. And writers must be able to file that complaint within 180 days of the alleged discrimination. And that is actually how long they have to file a complaint with the FTA regional office. But your complaint policy should mirror that as well. Again, you must develop a Title VI complaint form, and both of those should be posted on the recipient's website. And it's important both for ADA and for Title VI, you want to segregate the complaints that are coming in according to the type of discrimination. Obviously, you're going to have your, typical customer service related complaints, or actually, I guess I shouldn't say obviously. Hopefully, you're not getting those complaints, but it seems, it's something that does happen. So, but there's a difference between, my bus was late, the driver was rude, or the bus passed me by, and I think it's because I was Black. You want to be able to train your staff if you have a call center, anything like that, or people who review the complaints that come in through your website. You want to have them trained so that they can identify what complaints are Title VI related. So based on discrimination for color, national origin, and race. And so making sure that those are differentiated, and then that you are able to track those and have a separate process for handling them as well. And when Minnesota DOT gets reviewed for their SMR, then they're supposed to have all those complaints that their various subrecipients had during the last triennial process. So it's good that you track those and provide them to Minnesota DOT, or at least have them available so that when Minnesota DOT performs its subrecipient oversight reviews, then they're something that they can take a look at so that they're aware of what's going on. So for all complaints, you need to record them, you need to track them, and you need to report them to Minnesota DOT. Subrecipients can adopt the Title VI complaint investigation tracking procedures and complaint form developed by the primary recipient, but just remember, as we talked about earlier, subrecipients do their own plan. So the primary recipient has a plan, the subrecipients have a plan, it's contractors that are allowed to just use the subrecipient's plan as their own. So basically what I'm saying is that you can take Minnesota's procedures and everything like that and just drop them into your own plan. You can't adopt it technically, but you can use the same things if that's your plan that works for your agency. The circular does have a sample complaint form, and again, Minnesota DOT does have procedures for this that you can probably borrow from. And one thing to note with the complaint form is just for administrative practicality, then oftentimes you don't want to have 3 or 4 different complaint forms for all the different things that you have to comply with. And so you can have, for example, a joint complaint form that covers ADA and Title VI. You just have to have like check boxes that say, is it discrimination based on disability, or is it discrimination based on race, color, national origin? As long as they're differentiated, because you're going to have different systems for how you treat complaints depending on what type of complaint it is. But you can use the same form so long as it differentiates between the two. So for tracking complaints, Obviously, if it's a Title VI complaint, then you want to be tracking all active investigations conducted by entities other than FTA. So if there are lawsuits or claims, or something is before the EEOC, anything like that, then you want to be tracking those and aware of those. And any types of complaints or claims naming the recipient, Minnesota DOT, they're probably aware of those, but you want to be just tracking all of these so that you have an idea of what's going on. So the specific things that you're supposed to record when you're tracking complaints are the date that the investigation, lawsuit, or complaint was filed, a summary of what the allegations were, the status of the investigation, lawsuit, or complaint, and then any actions taken in response. So a couple of potential red flags that we see a lot are one, that an agency has no complaints, and usually, in my opinion, it's certainly possible for this to be the case, but it is a little bit of a red flag, because usually this means that either they're the best agency in the world, kudos to them, or they are not advertising their complaint process adequately so that the public knows of their right to complain. Because we know people like to complain, so having no complaints at all is pretty rare, and it does happen, but it's something that we see as a bit of a red flag. The other aspect is if you do have complaints, but all of your complaints in the resolution column of your spreadsheet or whatever, it says unsubstantiated, then that usually indicates maybe there are some problems with the investigative process, or at the very least, then you might want to add more information. Unsubstantiated because the complainant was unreachable, or unsubstantiated because we reviewed video of the camera footage and it didn't appear that anything had happened. So you just want to break that out and be a little bit more specific instead of just saying unsubstantiated across the board. Okay, so another requirement is that you have an inclusive public participation plan, your PPP, and this basically derives from Title VI, the actual legislation. There's an executive order on LEP, Limited English Proficiency, individuals, and then other LEP guidance. And the integration of these elements into each recipient's public participation process is very important. This is one of those, if you have a really strong public participation plan, then that's probably one of the most important things, because as we were talking about before, people don't know what Title VI is. They know that they're being discriminated against, or they think that they're being discriminated against, but they're never going to reference Title VI. So, but just making them aware of the protections and what your obligations are as an agency under Title VI is crucial. So the public participation plan in the Title VI program must explicitly describe proactive strategies, procedures, and desired outcomes. So in other words, what are we trying to do here as far as getting participation from the public and getting them to weigh in on our decision-making process? What procedures are we going to use along with those strategies, and what are the outcomes that we're looking for, and how do we get them? So the PPP should offer early and continuous opportunities for the public, including minority and LEP populations, to be involved in the decision-making process. One thing that we occasionally see is that the public participation plan is really oriented towards fare and service changes, but it's not oriented toward all the other things that you'd want to be doing in Title VI, such as educating the public on what the protections are, educating the public on what types of resources there are for their specific language, all those different types of things. So you want to make sure that your public participation plan is broader than just, holding a public hearing or something, if you're going to be doing a fare change or major service change, it should be broader than that. It should be periodic and trying to get input from the public that then can be considered and used in making any changes. So some best practices for good public participation plans. Scheduling meetings at times and locations that are convenient and accessible for minority and LEP communities. Holding meetings of different sizes and formats. Coordinating with local organizations, such as community and faith-based organizations, educational institutions, and other organizations to implement public engagement strategies. If there are churches or community groups in areas that are have a lot of a certain minority or LEP population, then targeting and working with those churches and groups can go a long way. Then in addition, use and consideration of various media. So if you know that there's a Spanish newspaper or different radio stations that are in different languages, then you could include notices on those different media. And then finally, providing opportunities for public participation through means other than written communication, such as allowing people to call in or capturing oral comments at hearings and that type of thing. Mariah, do we want to take a quick break and just see if anyone has any questions?
Sure thing. Yeah, we have gotten 2 questions so far about whether the PowerPoint will be available, and the answer to that is yes. The PowerPoint and also a recording of this webinar will be available, and I will be emailing that out tomorrow.
Okay, good.
That's the only question so far. If you guys send in your questions, like I said before, I will ask them to Matt.
Okay. So the next requirement for Title VI is providing meaningful access to LEP populations. And we kind of touched on this earlier, but we'll get into it now. There are really 2 components for providing meaningful access. And one is the 4-factor analysis, and the next is the language assistance program. And for for agencies who are developing their Title VI plan for the first time, or it's their first time dealing with these types of things, and this is one of the more challenging aspects. For the 4-factor analysis, then you're going to basically, I've seen these in a lot of different forms, and sometimes it's as simple as 1 or 2 pages, and other times then it's appendices of demographic data. But basically what you do is you look at, first of all, the number of LEP persons in your service area. And you want to look at that specifically broken down by language as well. And limited English proficiency persons, again, those are people who speak English less than very well. Those are that's the definition. So we first look at the number of LEP persons in the service area. Then we look at the frequency with which LEP persons come into contact with the program. So what this is basically alluding to is you could have a high number of Spanish-speaking individuals, but maybe they don't actually use your service very frequently because they're on the outskirts of your service area. It's taking into account those types of issues. Then we look at the degree of importance of the program. And I think we all know that in most cases, the program is going to be pretty darn important, and people are using your services to get to the hospital for medical appointments. They're getting to work. But obviously, it is going to have some variance from program to program, depending on what services you're providing and to whom. And then finally, we're going to look at the resources available for LEP outreach versus the costs of LEP outreach. So we know, obviously, that everyone wants to do the best job they possibly can, but there are also practical considerations of what your budget is and what types of outreach are necessary and achievable. So that's the basic for your 4-factor analysis. And so then your language assistance plan is made up, first of all, in the results of your 4-factor analysis. Second of all, it's going to include a description of how language assistance services will be provided. And it's important to note on this one that you're actually supposed to do this by language. So if there are differences in how you're going to approach language assistance, then those should be noted. And one aspect where this is kind of relevant is in cities that have very diverse populations, there are lots of different languages. Going back to the 4-factor analysis, we do know that we are looking at the availability of outreach versus the cost of outreach. And you could have a Title VI notice on your bus for Spanish, but you can't have a Title VI notice on your bus for 50 different languages. There's only so much room on the bus. And so if there are going to be differences in how you address languages, then those should be included in your language assistance plan. Next up, we're going to look at how LEP persons are notified of the availability of language assistance. So obviously, there's no point in having all these great resources if nobody knows they exist. So advertising the availability, and this is going back again to the public participation plan, that's one of those things. You don't want to just do it for major service changes and fare changes. You also want to take advantage of opportunities and public hearings and working with local organizations to make sure that everybody knows they have a protections in place against being discriminated against. So making sure that they're notified of the availability. The language assistance plan is the place where you kind of outline what your approach is going to be for that. Next up is how the recipient monitors, evaluates, and updates the language assistance plan. And so the language assistance plan is part of your Title VI plan, which gets submitted every 3 years. And so this would describe how you're going to take into account changes in demographics, how you're going to monitor changes in demographics, and update accordingly. You never know, somebody, we'll get to a discussion on the safe harbor threshold here momentarily, but for example, you could have a lot of people in the course of 3 years move in who speak a certain language, and so you want to be monitoring that and then updating your language assistance plan to address that and making sure that you're doing things like notifying them availability of language assistance, that type of thing. You want to have that all kind of laid out in a process in your language assistance plan. And then this last one is very important, how the recipient trains employees to provide timely language assistance to LEP populations. We see all sorts of different methods for this, but first of all, I think it's very important for you to train employees that obviously they have to abide by Title VI. They should know what protections the public has against discrimination. They should be trained for call center representatives and people who are evaluating complaints. They should be trained on how to identify those complaints and basically sensitivity training as well, and training on what to do if they encounter someone with limited English proficiency, how to resolve that person's issues. And so you have I speak cards, which are basically, they're a card that basically has like a sentence or two about how to get more information in 25 different languages or the top 10 languages in your area, training your employees to know how to use one of those I speak cards when they're operating buses. So there's a wide variety of the types of trainings that can happen, but you want in your language assistance plan to talk about what training you'll provide to provide that timely language assistance to LEP populations. So the safe harbor threshold is referring to the requirement to translate vital documents into other languages. And effectively what it does is it says that if you translate your vital documents into a language that exceeds the safe harbor threshold, then you are presumed to be in compliance with Title VI. And to trigger the safe harbor threshold, then it is if there's a language group, an LEP language group in your service area that constitutes either 5% of your service area or 1,000 persons. So if you have 1,001 people in your service area that speak Swahili and you want to ensure that you are abiding by Title VI, then you would want to translate all of your vital documents into Swahili. Now, again, we come into a similar situation where I was talking about before in New York with a very diverse population. Sometimes it's just not administratively practical or cost effective to translate all of your vital documents into every single language that exceeds the safe harbor threshold. So the key things in that situation are really in your plan. Then you want to explain what languages you're going to translate vital documents for. And if there are any that aren't going to be translated, then you want to provide a justification for why you're doing that. So maybe you translate vital documents for your top 5 languages, and then because the languages 6 through 10 are fairly low in number, then you decide that we're not going to translate all of those. But however, if someone from one of those language groups ever needs translation, then you'll translate whatever's needed on a one-off basis, something along those lines. So the next thing that you want to document in your Title VI plan is minority participation on planning and advisory boards. And note, this isn't your governing board. This is non-elected boards and committees. And basically, you want to have diverse non-elected boards and committees. Elected, it doesn't matter because obviously that's up to the populace. They're handling that. But if it's unelected appointed positions, then you want to have a reasonably diverse board or committee. And so in your Title VI plan, what you'd want to do is basically have a table depicting the racial breakdown of membership. And you don't want to just do, I say be specific, and what I mean by that is you don't want to just do, we have 12 people on the board and 4 are minority. You want to say we have 12 people on the board, 1 Hispanic male, 1 Black female, etc., so that you actually detail the different LEP groups that are participating. LEP or minority groups that are participating, excuse me. One crucial thing, and it seems like a simple one, but we occasionally see problems with this. The Title VI program must be approved by your board of directors or a governing entity responsible for policy decisions prior to sending to MDOT or Minnesota DOT rather. Not all policies have to go before the board. Oftentimes, financial policies can just be amended without doing that, or procurement. But for Title VI, then it's something where your Title VI plan must be approved by your board of directors before you send it to Minnesota DOT. So next, we're going to discuss some service standards for small fixed route providers. So for agencies that are below the 200,000 UZA and 50 peak vehicles threshold, then you're lucky in that you get out of a lot of things. You don't have to collect and report data. You don't have to evaluate service and fare equity changes for major service changes and fare changes, and you don't have to monitor your transit service. It's important to note that just because you don't have to do those things, it doesn't excuse you from complying with Title VI. You obviously still have to comply with Title VI. You can't be discriminatory. But the only thing that you actually have to do is set system-wide standards and policies. And so it's also, before we get into this, just a quick slide saying that these do not apply to demand response operators. We're just talking about fixed route. But the service standards that you're going to set, there are a couple different types. The first of which is vehicle load factor. You just want to make sure that you're not having crazy numbers of people on your buses. And I'll kind of jump to the end here on these service standards. We're trying to make sure that you're not having incredibly overcrowded vehicles that have 1 bus every 5 hours in a minority or low income area. And then the really nice brand new 2020 Gillig with perfect air conditioning and everything else going around every 30 minutes, 30-minute headways in the ritzy area of town. That's what all these are kind of aimed at. And so you want to establish service standards for what you're going to consider to be permissible on your vehicles. And in this case, with the vehicle load factor, setting a standard so that you're not going to have overly crowded buses in minority or low-income areas. You can develop different load standards for peak versus off-peak. Many agencies do. And you can also establish different peaks, different standards for the type and mode. And for small transit systems, you might have a couple different types of vehicles that it's totally okay to establish different load factors for each of them. So for vehicle headways just being the time between two vehicles in the same route. It's expressed in minutes. So a route with a 60-minute headway means that a bus would leave the downtown transfer center every hour. And so someone waiting for a stop would expect to have one bus coming every hour. So having a metric set for that. This is another thing that can vary by service type and by mode type and peak and off peak. On-time performance is another metric that you'd want to develop standards for. Just making sure that you have a definition of what constitutes on time. So in this example, 0 minutes early to 5 minutes late, you have a 5-minute window there where if you arrive during that period of time, that's considered on time. And then you have a percentage that is your objective for what percentage of the time you will meet that on-time standard. So for example, 95% of runs on time in that 0 minutes to 5 minutes late pocket. And again, like other standards, may be appropriate to define differently based off of peak and off peak and the different types of service. Lastly, I believe, is service availability. Just making sure that you want to have a certain percentage of the population within a specified distance to transit routes or stops. So this is meaning that you have routes that are serving people all throughout your service area in a fairly equal way. Oh, and distribution of transit amenities. These are things like shelters, benches, information that's available to ridership, and making sure that those are equitably distributed throughout your community. So again, you don't want to have in the minority and low income areas of town shelters that don't have roofs, so they get rained on when they're waiting for the bus. But then you've got really posh ones in the nicer areas of town with all sorts of brochures and provision of information, lots of information that's being given to them. You just want to maintain an equity between all of your ridership in this circumstance. And then vehicle assignment, the process by which transit vehicles are placed into service, just making sure that's fairly equitable as well. If you're just randomly rotating your buses or vehicles, then that's perfectly fine. You just don't want, again, the 2012 broken down, no working HVAC vehicles in the bad areas, and then the really nice ones in the more ritzy areas. So, and again, all of these are just setting the standards and then trying to meet them. Okay, so now we'll move into common compliance findings. Some of the most common ones are that the notice isn't posted everywhere that's listed in the plan. That's usually something literally when we're walking into an agency and they've got, we'll have read the plan before going there. And if they say that they're going to have it at the front desk and we walk in for our first meeting and it's not at the front desk, then that's an issue. And not being posted in public places, if you don't, if in your plan you state where you're going to post it, but for example there are major places left off, we're probably not going to ding you for that. But at the same time, then it should be posted in the majority of public places where your ridership is going to encounter them. So that might mean bus stations, at administrative centers, at facilities that are open to the public, any place they can buy tickets, on your website, etc. And then a lack of evaluation in outreach efforts. So one thing that we see very frequently is, so you do your public participation plan, you're holding public meetings, you're having people write in and all this stuff, and that's all great. But one thing we definitely want to see in your public participation plan is how that information, that feedback from the public is actually being used and considered, and it's going to influence the decision-making process of the agency. So identifying and being able to explain that in the public participation plan is really, I would say, important. And then with a lot of Title VI, then what happens is no matter what's in your plan, then the reviewers are going to be looking to see how you've implemented your plan. So if that's in your plan and you're not implementing it at all, then that's a problem. If it is in your plan and you are doing it all, then that's great. But basically with all these, your plan should be good, your notices should be good, and then you definitely want to make sure, again, that you're doing whatever is actually outlined in your plan. With the 4-factor analysis, there are all sorts of ways to screw this up. One of the main ones is by looking at the ethnicity of the service area population as opposed to the language spoken. It doesn't matter if 13% of your service area is Hispanic. It matters what percentage of your service area speaks English less than very well. So you don't want to focus on ethnicity. You want to look at the language spoken, and those who are limited English proficiency speak English less than very well. Then another thing is failure to find data in the Census American Community Survey. So we know that this is a census year. So the census is performed every 10 years, and usually it takes 2 to 3 years before they're actually able to work through the data that they've collected and publish an accurate census. So it's really unreliable to use the census, oddly enough, because it's just happens so rarely and there's such a lag time. American Community Survey is basically a division of the census, and it comes to its own numbers based off of some of its own research, and it publishes that on a yearly basis. And so what we don't want to see in your 4-factor analysis is language data from the 2010 census when it's 2020 and we're awaiting the 2020 census. What we want to see is the most recent American Community Survey data, which I believe right now I think is 2018. So if you have that, then that's a much better indicator of the actual state of your demographics than what the census is. And again, we want you to be using that most recent census data, American Community Survey data. Sometimes we see with the safe harbor that people confuse the 5% versus 1,000 people, and they think that it is whichever is higher. So in other words, if 6% of the population, if there's 5,000 people and that's higher than the percentage for the population, they'll follow that when it's actually supposed to be whatever's lower. And then in addition, not translating all the LEP languages above the threshold, and then not justifying the reason for not translating them. If there's a language that's above the safe harbor threshold, then you definitely want to, in your plan, indicate why you're not translating it. And it may be because it's not cost effective. It may be because you've got driver surveys that say that you rarely encounter certain LEP populations in the course of operating. It could be administratively impractical. You may not have room on the buses for all the different languages. All those types of things are perfectly valid reasons, but you want to have that explanation. With the complaint process, It's a little shocking, but oftentimes we don't find information on how to file a complaint readily available to the public. And this is something we, before we do a review, we go to someone's website and check them out, and they should have a Title VI complaint form and a Title VI process and a Title VI notice, all very conspicuously available on the website. If we don't see that, then those are all red flags. No formal processes for tracking complaints, investigating complaints, or resolving complaints. Again, much like with ADA, with Title VI, you have to have specific ways of doing all these things. You can't just handle complaints just as you would any complaint that's coming in for whatever reason from the public. You have to have specific processes for Title VI complaints that are alleging discrimination on race, national origin, color. And then you want to make sure that you have a good complaint record keeping system, because remember, Minnesota DOT, when they get their state management review, they're going to have to show that they're monitoring Title VI and adhering to Title VI, and that their subrecipients, because the subrecipients stand in the shoes of the direct recipient, that the subrecipients are tracking all of their complaints and have that information available should FTA like to see it. And then continuing on with that, failure to report the complaints to the primary recipient. And for this last one, I would say it definitely makes sense for large complaints, lawsuits, anything naming Minnesota DOT or potentially putting FTA funded assets in jeopardy, notifying Minnesota DOT of anything like that. Depending on Minnesota's preferences, you may be able to, for regular just run-of-the-mill complaints, track those within your agency, and then have, when Minnesota has subrecipient oversight reviews, showing those to the reviewers at that point. If Minnesota is okay with that, then that's probably the more efficient way of handling kind of your everyday complaints. Another one that we discussed earlier is expanding the Title VI notice and including criteria other than race, color, or national origin. And website links. Because obviously you're submitting your Title VI plan every 3 years, you want the most recent one to be on the website, and you want to make sure that the links are accessible so that if a member of the public wants to see your plan, wants to see the notice, wants the complaint form, that those are all working and available to them. Not revising Title VI plan on FTA's request. So when you submit a plan to FTA, or when you submit a plan to Minnesota DOT, the common practice is that FTA or Minnesota would issue what's called a concur letter. And oftentimes the concur letter concurs with your plan, but then asks for additional things to be done, for revisions to be made or additional changes. And basically what they're saying is that that has to be done by the next time you're reviewed. And so in the case at least of recipients, then that would be their next triennial review. And so if we do perform a triennial review and we get on site and there were conditions to the concur letter, that they concurred with it only conditional on certain things, additional things happening, and they haven't made those changes, then that is a finding. And so I assume that there is something similar to that in Minnesota. And so just making sure that if there are any conditions or changes requested that you make those changes. Opportunity for public involvement, going back to our public participation plan, failing to provide that early and continuous opportunity for public input. We talked about just having town halls and whatnot for major service changes or fare changes. You really want to be doing that to educate the public on their protections and what available language assistance is available to them. A lack of service policies and standards for Section 5311 fixed mode providers. not having those service policies and standards that we were talking about earlier, not having those identified. And translation of vital documents. We talked about Google Translate. If you do use Google Translate to translate a vital document, in other words, one that communicates rights, then you have to have someone who speaks the language fluently review it and make sure that communicates the spirit of the protections there, make sure that's accurate. We would hope that Google is on the ball about their translation services, but we can't rely on that. Again, the automated translation is frowned upon by FTA. And then obviously failure to translate vital documents. One thing to note, even with the safe harbor threshold allowing certain documents, if you justify them, certain LEP populations documents to not be translated, you do need to know that just because you decide not to translate them, or they only have 700 people in your service area or something like that, if they do need translation, then you need to translate those for them on a one-off basis. So just because they're not an identified LEP population doesn't mean that you get to not translate their documents if requested. The 3-year update requirement for FTA, then again, that your Title VI plan is due every 3 years, at least 60 days prior to the expiration. Theoretically, that gives the regional civil rights officer some time to review the plan and then concur with it before the expiration of your current plan. It doesn't really work in practice. The regional civil rights officers, of which there are 10 in the US, are usually very behind, and so I would say that's probably almost never going to happen where they actually review it and concur within 60 days. But that's nonetheless the date that these are due. Failure of the entity to formally approve the update. Remember, the Title VI plan has to be formally approved by your board of directors. And then failure to update the LEP section. This is the demographic data where we want you to use the American Community Surveys so that we've got the most recent up-to-date data for your 4-factor analysis. So at this point, then that is the conclusion of the presentation. I'm more than welcome to take any questions if anyone has written in any or has any last-minute questions they would like. I'm happy to address those.
We don't have any questions yet, but maybe we can just wait 1 minute, and if anyone has any questions, go ahead and ask them now. We got one comment from Kirk Kuchera. He said, thank you, Matt and Mariah.
Oh, great. You're welcome.
We have one person who raised their hand. Yep, okay, so Melissa Hansen asked, if we think of a question or need to help down the road, is it okay with for them to contact you at a later date?
Yeah, actually, maybe what would make the most sense is, since we do have another presentation that we're going to be doing in a couple weeks, if anybody thinks of any questions after the fact, maybe they can send them to you, and then you can kind of group them and send them to me.
Yeah, that sounds great. I will be emailing everybody who registered and also anyone who attended today's webinar. So I will include my contact information obviously in the email that I'll send you. So if you guys want to reply with any questions to that message, I'll collect those and get them to Matt before the next webinar on the 18th.
Okay, very good.
Great. And that webinar, if you haven't already registered for it, is open for registration at mnrtap.us. So it looks like we don't have any more questions. Is there anything else you wanted to add, Matt?
No, that's the conclusion of my presentation.
Terrific. Well, then that concludes this webinar, and you can expect an email with the PowerPoint from us tomorrow. Have a great rest of your day, everybody.
Great, thank you. Thank you, everyone.